Hello, everybody. I am Paul Brody. I'm the Global Blockchain Leader at EY, and I'm delighted to welcome you to this blockchain webinar. And our focus in this discussion is 2024, the year of MiCA. Now, if you don't know what MiCA is, you will soon. And if you don't know much about it, you will understand very soon why this is such an incredibly important piece of legal legislation that's taking place and taking effect this year. MiCA stands for Markets in Crypto Assets. And our webinar today is all about doing a little bit of a deep dive into the enormous scope of what's happening. So why don't we go ahead and get started? Let's go to the next page. So first of all, we just have our standard disclaimer. So I used to make up funny things to do with this, but legal said, don't, just let the disclaimer stand for itself. I want to talk briefly just about the amazing speakers, because what we have done today is line up some of the most incredible experts that you can find on this incredibly important law. We're going to start with Martin Hansel. Martin is he's the head of New Tech at EY Law in Austria. Martin is an incredible speaker. He's spoken recently at ETH Denver and a number of other events. Martin, welcome. Thanks for joining us today. Thank you very much. Secondly, we are joined by Fabian Reinisgch. Fabian is the general counsel at Bitpanda. Bitpanda is regulated in multiple European jurisdictions, and obviously he is going to be an expert on MiCA and its impact. So Fabian, thank you for joining us. Thirdly, today we're joined by Ralph Rirsch. Ralph is the assistant general counsel and the MiCA lead, so he's a specialist focused on MiCA at the Kraken Digital Asset Exchange in Europe, and he is joining us with a collared shirt on, which is kind of making me look improperly dressed. Ralph, thank you so much for joining us.
Great to be here. Happy to pull the crypto bro on you in reverse, man.
Thank you. And lastly, we have Marie Winter, another attorney at law from the New Tech team at EY Law, and another one of our deep MiCA regulatory experts. Maria, thank you for joining us. Marie, excuse me, I got it wrong. It's Marie, right? Sorry about that.
Marie,
excellent.
Thanks.
And let us go to the agenda. Let me take you through what's going to go on today and a couple of kind of housekeeping items. So first of all, we are going to do, Martin and Marie are going to take us through a regulatory deep dive. What is the scope? What are the issues? What are some of the key features that you need to understand in order to take advantage of this law? And then after that, I've got some hot questions for our panel of experts. We're going to spend some time doing that, and then we're going to close up with a general session and a Q&A where we will also take questions from the audience. So it's going to be very good. Before I hand it over to Martin, I just want to I want to do two things. Number one, I want to just put this briefly in a little bit of perspective. The entire global cryptocurrency and blockchain industry today is less than $2 trillion. And all of that adds up to 1% of the regulated assets that exist in the global financial system. MiCA opens the floodgates for all of those assets, well, maybe not all of them, but a sizable portion of them to move into crypto, to be tokenized, to be digitized in ways that they haven't been before. People need to really understand that what we're talking about here is a sea change in the regulatory coverage and the ability to do things in the world of crypto. So adjust your thinking about the order of magnitude that we are looking at. Secondly, just a little bit of housekeeping. For those of you who are joining online, if you registered with the system, you will receive a copy of the slides after today's presentation. So don't worry about that, and don't ask 20 questions about, are we going to get the slides? Yes, you will. And in addition to that, at the end, we will also have an NFT for you, so have your cryptocurrency wallets ready for that. With that, I would like to hand over to our opening kind of keynote speaker, Martin, to talk about the regulatory deep dive around MiCA. Martin, are you ready to join us? Well, Martin, I think you might be on mute.
Oh, thank you. Thank you very much. And also very, very happy to give this first talk about MiCA and kind of an introduction of what this regulation will bring over the next couple of years, actually. And it's going to be in effect and applicable this year still. So MiCA, if we go on the next slide, what is MiCA and why is that so important? Paul, you already briefly touched upon kind of that it might even also open up crypto assets and in tokenization to TradFi, but also merely speaking from a crypto and fintech perspective, MiCA is huge because right now we have in the 27 different member states, we have 27 different sets of crypto regulations. So if you want to be active in the European Union, you will have to comply with all of the different local laws. And this will change with MiCA because with MiCA, you have one uniform EU regulation for crypto assets, and you have to get licensed once, and then you can passport all of your services throughout the European Union, which then again, we put it here on the slides, could be your golden ticket to the EU market and actually grant you access to a 450 million people market, which is huge, and it is a huge business opportunity also from that perspective. So it might be worth having a closer look at what is actually covered under MiCA, and we'll do that on the next slide, because basically you can look at MiCA from two, that MiCA has two pillars. On the one hand, it covers issuers of tokens, namely issuers of unbacked crypto assets, asset reference tokens, and e-money tokens. In these categorization, we will have a closer look at this categorization a bit later on, and especially also in terms of asset reference tokens, because that could actually be a huge new business opportunity where we open up the market to new products. And the second pillar of MiCA is crypto asset service providers, is directed at crypto asset service providers providing services in relation to crypto, which could be, so to say, classic services such as custody, exchange, the operation of a trading platform, or advice or portfolio management in relation to crypto assets. And all of those services will then, under MiCA, it will be possible to have these services on an EU level, provide the services on an EU level, which will be a very interesting change, and where we also see that a lot of crypto brokers and exchanges are now kind of preparing already for MiCA, because everyone, of course, wants to be amongst the first exchanges or brokers to get a license to be able to market throughout the European Union. Equally important to what is covered by the scope of MiCA is also what is not covered by the scope of MiCA, and therefore does not benefit from, on the one hand, the single license principle and the passporting, but also might still be unregulated and might still be provided on an unregulated basis. We put down here on the right side of the slide some of the buzzwords that you might already have heard in that context. On the one hand, MiCA will not be applicable to decentralized finance if it is truly decentralized, and that's exactly what MiCA says, right? It says it will not be applicable if it's truly decentralized, but no one actually defines what true decentralization means. So what we will have to deal in the future is with projects that have some kind of a decentralization, or to some extent a decentralization will have to be determined whether these projects fall within the scope of MiCA or not. What is interesting in that context is, for example, that a lot of regulators have already expressed that they think many companies and many projects that are operated via a labs company might be centralized, at least to some extent, and therefore some of those operations could fall under the scope of MiCA. This is something to really keep into account, because only because you call something decentralized doesn't necessarily mean that it's actually decentralized from a legal perspective, and therefore really out of scope of MiCA. And if you want to look that up, most recently the German regulator expressed something like this in terms of Uniswap. So that is something that you can look up and also do your own research on that as well. Something else that has come up several times is tech providers are not in scope of MiCA. Again, here it has to be determined whether it's really a mere tech provider, and it has to be made sure that tech providers do not provide any of the services outlined here in the service providers section. Which means basically, for example, if you provide a custody solution, you have to make sure that you don't really own the private keys or have control over the private keys as a tech provider, because otherwise you could fall in scope of MiCA and provide custody services. A very important exemption, and then we might go on to the next slide. But a very important exemption is also that everything that is covered under the traditional finance regime, meaning securities or financial instruments, is also not covered under the scope of MiCA. Which means, and this is because these financial instruments are covered already by TradFi. They are covered, for example, by MiFID II, and therefore it is very important to always distinguish whether your crypto asset is actually a crypto asset that falls under the scope of MiCA, or whether that could be a crypto asset that falls under the scope of MiFID, and therefore a different regulatory framework applies. This is particularly challenging when it comes to asset reference tokens and potential products that are structured around asset reference tokens. But we will have a look at that in a few minutes, and then you will see kind of how and why this is important to always take into account. Now we figured out kind of what is the material scope of MiCA, what is covered, which services, and who are the addressees of MiCA. What is actually the geographical scope of MiCA? Because what we get asked also in our practice quite often is, are non-EU firms covered by MiCA, and how extensive is the geographical scope to be interpreted? So basically what we can say is, on the one hand, no non-EU service providers are in principle not covered by MiCA, so they do not require a MiCA license. And they can also, to a very small extent, talk to or onboard European customers if European customers initiate all of initiate the business relationship with this non-EU based service providers. But, and you already noticed that I was very cautious in how to phrase this here, we see that especially European and also the national regulators have expressed that this kind of reverse solicitation from non-EU companies and non-EU licensed companies will just be possible in a very, very narrow way. So what we would expect is that, and because in the draft guidelines and draft consultation papers that you might already have read on reverse solicitation, it is stated that whenever you at some point solicit and direct the services to the European market, e.g. by having your website in a European language, in an official European language, of course, other than English, that this is already considered as active solicitation of EU customers. So, for example, if you provide your website and homepage in German, that would likely already be some kind of active solicitation of EU-based customers. Or also if you provide Google ads that are directed at EU customers, or similarly also if you sponsor big sport events that also take place, or big sport groups and that also have a presence within the EU. For example, if we think about Formula One races, this could be again already some kind of solicitation of EU customers. So what we expect in practice is going to happen is that almost all of the larger exchanges or brokers situated outside of the EU will at some point require and also apply for a MiCA license to not only so that they can actively approach the EU market. And if you now kind of, after very briefly talking about MiCA, talking about what the scope of MiCA is, you think you might need a MiCA license, we should have a look at the timeline on the next slide, what to prepare and when to prepare these things, and when will the whole thing be actually applicable. So there are actually just two very important dates that we want to briefly touch upon today, which is the first date, the 30th of June 2024. As of the 30th of June 2024, the provisions for asset reference tokens and e-money tokens will apply. So from that on, those issues will have to have the corresponding licenses. And from as of the 30th of December 2024, so end of this year, MiCA will apply in full, which means also the regulations for other unbacked crypto assets will apply as of this date, and also the provisions for crypto asset service providers will apply at this date. At this date, we already see, especially because I already touched upon this at the beginning, we already see that a lot of crypto asset service providers want to be the first mover, want to have one of the first MiCA licenses within the European Union, and that actually very much depends also on the jurisdiction that you choose and how you approach, how you can already approach the regulator of the respective jurisdiction. So it is still very interesting to see which of the countries might accept, because all of the countries and all of the regulators have to accept MiCA applications as of the 30th of December 2024. But some of the countries or regulators might already accept MiCA applications before that date, and this could then be a competitive advantage for companies applying for a license in those countries. So that is just something also to keep in mind when you're currently in the process of choosing the jurisdiction for your MiCA operation. Let's now maybe have a closer look at the MiCA regulation, especially on the issuer side and a crypto asset service provider side. If we can go to the next slide, we will focus exactly on token issuers and crypto asset service providers. At the beginning, I already touched upon this, that MiCA in general differentiates between three different forms of crypto assets, namely other crypto assets, asset reference tokens, and e-money tokens. And the issuers, and depending on which asset you issue, certain requirements apply to the issue of such crypto assets. So other crypto assets are typically utility tokens, layer 1 or layer 2 coins. This is basically a catch-all category for the different types of crypto assets, which means any representation of value or rights which can be transferred and stored on a DOT technology or a similar technology. So that is actually a very broad definition of a crypto asset, and therefore MiCA wants to cover a lot of different crypto assets. It becomes more interesting if we think about asset reference tokens and e-money tokens. Maybe to briefly go to the right and talking about e-money tokens. They try to maintain a stable value by referencing only one fiat currency. So typical examples would be what we colloquially refer to as stable coins, with USDC, for example, or USDT. Those coins will likely be covered under MiCA as an e-money token, and will require the corresponding licenses as of MiCA being applicable. That is also pretty straightforward, right? So I think most of us would agree that a token that references just one currency is similar to e-money, and therefore should be covered by this regulation. What is more interesting and also brings new business opportunities is the asset reference token. Because as you can see here on the slide, the definition of an asset reference token is that it maintains a stable value by referencing a basket of, or just one asset that could be a commodity, a crypto asset, or several fiat currencies, or any other underlying of value. So what we see now in practice is that also TradFi companies are thinking about issuing asset referenced tokens as for some form of an investment vehicle, right? So for example, if you think about an asset reference token referencing a precious metal or a basket of precious metals or a basket of different currencies, that could actually open up, as Paul already said at the beginning, a whole new asset class that and could be very interesting, not only for native fintechs or native crypto companies, but really also for the TradFi sector. So this is something where we are very excited about, but this is also probably the most challenging part of MiCA, at least when it comes to interpretation, because when you structure a product or when you want to structure a product as an asset reference token, you have the upside that you can then market your asset reference token throughout the European Union and throughout the European Union with just one license, and you do not have to think about the different implementations of MiFID in the different countries. But this is but at the same time, as it reminds us of classical financial instruments, we have to be very, very detailed and have to make sure that when we structure an asset reference token, we actually structure an asset reference token and not a financial instrument like a derivative product or something like that. So this is kind of something super exciting on the one hand, because it could open up a lot of new business opportunities for a lot of different players, and not only native crypto players. But at the same time, it needs some careful consideration and structuring to actually be able to leverage the MiCA setup here. And if we go on the next slide, just very briefly talk about the crypto asset service providers, because those are kind of the second pillar of MiCA. How do we actually get a MiCA license, or how can crypto asset service providers be active under MiCA within the European Union? In general, you have three possibilities. You have the standard authorization process that you just go to any of the 27 regulators and initiate the MiCA process and submit your application there, including all of the required documents, which are a lot of policies and kind of these documents that we know from TradFi institutions. The second option would be that you use the simplified authorization for companies that are already registered as virtual asset service providers in one of these countries, in one of the 27 member states. Whether this possibility is open for you or not, it very much depends on the jurisdiction where you are currently registered as a VASP, because not all of the member states use the possibility to offer a simplified authorization for already registered virtual asset service providers. And the third possibility to offer crypto services in the European Union is the notification according to Article 60, which basically is a possibility for already licensed traditional finance institutions, such as credit institutions or investment firms, that now also want to offer crypto services. So that could be the third option to really offer crypto services upon MiCA being applicable. Now, what we want to briefly still talk with you and briefly touch upon before we go in the panel discussion would be on the next slide, market considerations that we have been seeing. But again, Fabian and Ralph, of course, are very welcome then to either jump in here or discuss with us these things that we have been seeing in the market in the panel discussion later. So in general, we see that a lot of countries, a lot of companies have three topics that they are currently dealing with, or three big topics that they are currently dealing with. On the one hand, the question whether it still makes sense to go for a VASP registration, which is a registration as a virtual asset service provider under the current regime, or whether you should straight go for a MiCA license, or if you have already VASP registrations in some of the member states, whether it makes sense to use the simplified authorization procedures if they're available in that country, or go for a different country for MiCA. So this is kind of the first big topic that we see a lot of companies are dealing with right now. The second question is the choice of jurisdiction. Of course, I already said at the beginning, with MiCA, one of the huge things is that we have a uniform EU regulation, that all your services can be passported throughout the European Union with this regulation. But especially at the beginning of the authorization process, it still can make a difference in terms of where you have your headquarters, and which jurisdiction you will actually go for in terms of for a MiCA license. And some factors that we see that companies are discussing is, on the one hand, reputation of the jurisdiction, especially also in terms of AML compliance, the expertise of the competent regulator. There they look at the MiCA department. Will it be the same department as the virtual asset service providers? Who are the people actually being responsible for MiCA? How many applicants have already confirmed or publicly confirmed that they will do MiCA in the respective country, and does that match the size of people that are at the regulator, kind of also to ensure a smooth and fast process here, aligning possibilities, market dynamics, and of course the access to talent, to the talent pool, and also whether it's possible and how easy it is to attract people to relocate to this new country where they intend or think about going for a MiCA jurisdiction. But of course, there are lots of other factors to consider as well. And one important consideration always is tax. And here we see that much more that it is much more that is being discussed than just the corporate tax rate, but also the possibility to obtain tax rulings, structuring options, or the personal tax situation. So moving on to the next slide, where do most of the people stand or companies stand in their process of obtaining a MiCA license? What we see in practice is that especially non-EU based companies are very often still at the beginning of this timeline, with, for example, the strategic decision to now focus on MiCA in the process of evaluating the different jurisdictions for their potential MiCA hub and starting their gap assessment, whereas a lot of EU-based crypto asset service providers are already drafting documents or even pre-aligning the documents with the regulators. So more on the right side and the end of the MiCA timeline here to say, but we hardly ever see any crypto asset service providers that have not yet started or that are ready for submission. So those are kind of the both extremes that we currently do not see anymore. If we just move on the next slide with before we get into the panel discussion, what are hot topics that we currently discuss with clients, or that we see that clients discuss also internally. On the one hand, of course, and just briefly to touch upon a few, and then again, Ralph and Fabian, please feel free to jump in and discuss this with us also in the panel discussion. We see that with MiCA, clients are thinking, or companies are thinking about whether they can build new products, what products, how those products could look like. Again, refreshing your memory, we talk a lot about asset reference tokens and how those products can be offered within the European Union. Then, of course, the gap assessment, mapping your current operations against MiCA requirements to see how far you are with the process, and then maybe also just to touch upon this one point also here, the proper insolvency proofing that we have, kind of the question where we see that this is a big part of MiCA and is also being heavily discussed within companies, how to do this insolvency proof custody in compliance with MiCA. And to conclude here, we have, and you might are aware of this or not yet. We especially kind of with EY, we do not only offer EY consulting services. Maybe you can move on the next slide. But we also offer legal services especially in Europe and the Americas as fully licensed law firm. So that is something where we can really support as a one-stop shop. Good. That would be kind of my quick intro as to what we see in the market and kind of what we see and what MiCA is about. I think we could then switch to the panel, and if you can please go.
Terrific, Martin. Thank you very much. So yeah, we've got two things that we're going to go on now. So first, we're going to go into our panel discussion, and I have prepared some brutal, hardball questions. No, just prepared a few questions for our expert panelists, and then secondly, while we are doing that, the Q&A system is open. So if members of the audience have questions, you can put them in there. Or if there are no questions, everybody will be subjected to a 15-minute slideshow of my recent holiday in New Zealand. So you don't want that. You really don't want that. So come up with some good questions. I want to start off. So Martin, that's a very, very good deep dive. I want to start off. Actually, I want to start with Marie and a question for you around consumer protection. So one of the conversations that Martin and I have had several times around MiCA is it basically provides a legal framework for any kind of crypto asset. And that means that there can be a huge number. There's already an enormous number. How will this improve in any substantial way the level of consumer protection? Because I think this is one of the things that, at least in the US, regulators are very negative on, is the consumer protection for people buying crypto and digital assets.
Yes, Paul, very, very interesting. So the MiCA is not a consumer protection regulation per se, but there are several pillars within MiCA that help to improve the consumer protection level for European customers. And it in particular tries to establish a playing level field between the investors and the service providers. And first of all, it does so by having disclosure of information of the service providers in order to allow the investors to make informed and risk-based decisions. But there are also other pillars that help consumers in that way. For example, by introducing own fund requirements, but also fund safeguarding requirements or fund segregation requirements. And lastly, which also helps consumers with MiCA, is that it helps consumer protection agencies in the different national states to enforce these rights and to also establish complaint mechanisms.
Now, I guess I want to sort of throw this question open a little bit to Fabian and to Ralph, and to ask you, obviously you're both focused on MiCA from a compliance perspective, but is the expectation in your companies that MiCA is actually going to increase consumer confidence in the crypto space, and is that going to lead to more end users or end consumers investing in this area?
I mean,
thanks. Ralph, you want to go first?
Yeah, I mean, I can go first, and then you come in however you want to do it. So just my general disclaimer, I'm not a Kraken spokesperson, so I'm just like giving general remarks here, but everybody in the space is excited about this as well, right? Because we think giving this kind of the regulatory stamp of approval is a big step for the market, although most of what is in the regulation that Marie just mentioned, like the good ones in the market already do, right? Like asset segregation, like having actually the proper client-facing policies, all of that. But I do think that it will create a big shift in professionalization, especially for the smaller players who usually drag down the market when something goes wrong. And also because there is then actual supervision, and regulators can't say, okay, we're not looking at this. This is unsafe. At that point, they will actually have to look at this and also take a position there. So I think it's going to be a net positive. Of course, a bit of pain, but yeah, good thing for consumers too.
And Fabian?
Yes, thanks for that. I think in general, MiCA will be a complete regulatory shift, what we will see, but also as one of the brokers with the strongest regulatory setup actually in Europe, we were also kind of well prepared already for MiCA. The thing is, like, we are clearly following everything what comes from the EU in this regard, and also on the clarifications on level 2 and level 3, what is now coming next. But I think what's important is that you really go in with a holistic approach when you look into your company. MiCA is not solely about getting a license and actually having a compliance setup in place. It's like really all the operations kind of have to be in compliance with the law, and that you can also get the license. So it will lead on the one hand to a professionalization of the entire industry, which I think is great. And also to your comment, what you said at the beginning, there will be a lot of money coming into the market, and also a lot of new business opportunities. And I think this is great. And also talking a little bit about what will change in terms of competition, because the thing is, like, at the moment you have so many international players who can just target the market in Europe without having a proper setup, without adhering to actually consumer protection rules, without following the regulatory framework. And this needs to change, to be honest, because the thing is, regulated players in Europe actually are setting a very, very high standard. And also I think for the industry to invest and to have trusted players in the market, it's also important that you can actually sort out and kind of distinguish yourself from unregulated players. So there is, I think, a massive shift incoming, which is highly appreciated also from our side, because it was always a clear direction to actually have clear rules, and that we are also part of the financial industry, but kind of bridging the gap to the Web3 industry, more or less.
So one of the things that I certainly hypothesize is that right now, a lot of investors who have significant amounts of capital, if they are inside a regulated environment like a pension fund, they're not going to put that money in an offshore exchange. And today, and actually I was doing some analysis for our own blockchain summit in a week or two, what I saw was that today, 80% of global trading volume in the crypto space is actually done in offshore trading environments. And so my expectation is that MiCA is going to be one of the key things that brings that transactional volume. There's going to be a shift, and I will be willing to bet that 4 or 5 years from now, it'll actually be flipped. 80% of trading volume will be done onshore in regulated markets, because that's where most of the capital is. And if you're a pension fund, if you're a European pension fund, you are not going to buy crypto assets through some company in the Seychelles or the British Virgin Islands when you have a regulated participant inside the EU that you can work with. So I want to come back. I'm gonna kick another question back to Marie here, which is obviously there's the world of DeFi and there's the world of sort of more centralized platforms. More centralized platforms that have traditional terms and conditions that look and operate like banks and do KYC, are they going to have to change some of their regulatory or their T's and C's substantially? Or is this going to be pretty much for the big players? Is this going to be just continuation of business as usual because they're probably already in compliance?
Well, this depends. I mean, most likely the TC sets have to change, but there will be big differences, as Ralph already said, between already established players and not established players, because currently we see very big differences between the different TC sets of different service providers. This is mainly currently because there is no regulatory framework that sets the contractual setups and the internal policies. So to a big extent, currently this is up to the service providers. And with MiCA, this will change a lot because MiCA significantly extends the scope of the regulated aspects. For example, under MiCA, there is the requirement to have a detailed custody agreement between the service provider and the client. And currently, what we see, if if at all if there is a custody agreement. Mostly in the TNC setup, it is high level, but with MiCA, this custody agreement needs to include, for example, a very detailed description of the services. It needs to explain in very much detail what the custody setup is, what security systems are in place, but also which costs and which fees a customer has to bear. So what we think is yes, it will have an impact and changes of the setups of the TNC sets. The regulatory setup will likely be necessary.
Okay, so we're talking about a fair amount of work here. So maybe my question then, I would sort of kick over to Fabian, which is, okay, given the amount of work that's involved, how far in advance should companies be planning, right? I know this law is coming into effect. It's starting to come into effect in June of this year. How far, for how long have you been preparing? And what would you say to companies that if they have not started preparing yet?
Thanks for the question, Paul. I think also to add to what Marie said, I think it's really important that you have, the right advisors and also the right in-house people in place to be MiCA ready, because especially when you talk about the customer-facing documentation, but also how you speak to the regulators, you just need, on the one hand, to have clear guidance, but I would also say you have to be a little bit brave, because we're talking about the new regulation. You will get a lot of fuss around like how strict you can interpret MiCA, but we do not want to prevent business, I think. The thing is, MiCA should provide clarity, it should provide investor protection and also market integrity, but in general, the goal is still to actually have a harmonized regime and have a very strong business setup for Europe. And therefore, I think this is a little bit still the challenge to actually have this clarity at the moment, because there is a lot of guidance on level 2 and level 3 regulation, but still it's not sufficient, and authority guidance is also missing. National implementation laws are not there yet, so it's difficult to navigate. But I think, and probably Ralph can agree to that, we are working quite long already in this industry. It's like really you are used to work in a gray field and actually to shape the industry into the right direction. And in terms of preparation, so to answer also your question here, is like we are on this already, I would say the past 6 to 12 months. The thing is, like, you had an initial kind of project team, which is mostly focusing on the regulation itself and how to interpret the regulation. And then we were really shifting into a program management where we really say, okay, what is the actual effect on each and every department in the whole company, and how we can really prepare ourselves best to be first in the market, to get the license, and also kind of to pick up the regulators we are working with, and to provide them with a good presentation of our very strong setup, because it will be just a competition disadvantage actually when you are not one of the first who receives the MiCA license. The thing is, we can already serve customers in more than 20 jurisdictions in Europe, but the thing is still, when you want to really target even more markets, and also when you want to for sure attract institutionals or general businesses, it's just necessary that you comply always with the highest standard in regulation, that you actually have a license.
Right. So I would say, I mean, it does feel a little bit like the EU has kicked off a bit of a race to the top and in setting kind of the global benchmark in this area. Now, before I go to the audience Q&A, I've got 2 remaining questions that I want to get to, and I want to get to them focused around DeFi. So I want to start with Ralph, right? DeFi is not within the scope of MiCA, right? But I do think that, it's going to be impacted by MiCA, and DeFi is, I believe, although DeFi is very, very down at the moment, I believe as interest rates come down, we're going to see the search for yield resume, and people are going to be piling back into DeFi in search of some kind of way to make their existing assets deliver more. So how is MiCA going to end up affecting the world of DeFi?
So I think it's going to affect it quite directly, because the centralized exchanges are the gateway to DeFi, right? DeFi currently doesn't operate without centralized gatekeepers. Also, all of the native token prices come from centralized exchanges. All of the secondary market trading happens there. So anything that happens to the centralized gatekeepers immediately also happens to DeFi. So if there is, for instance, an issue with, let's say, a decentralized token, there is something like a product intervention, or is a regulator taking a position against it, they of course will have a hard time enforcing directly against the decentralized protocol, but they can attack, and they will, I guess, the gatekeepers. So if they force us to delist a certain asset, for instance, that will be a huge issue. The AML CTF stuff is going to be a huge issue for DeFi, right? It's very hard to establish source of funds, especially going forward. With the new regulations coming in there. Another piece that we really have to think about and can't ignore is the fact that USDT, right, is one of the most important stable coins for the DeFi space. And like, I don't want to speak for the people there, but they, like all of the major single currency stable coins, face huge challenges coming up in the near future. And we don't yet know how regulators will interact with centralized exchanges regarding that. So if that liquidity is cut off, it's going to be a very interesting new world for DeFi. So there is very things that are coming up soon that are going to be very impactful directly out of MiCA.
Absolutely, and so you brought up kind of, I think, like it's the stablecoin elephant in the room, which is the fact that by far the biggest stablecoin is kind of a less regulated offshore entity. And I want to turn to Martin because you and I have talked about this a bunch of times, right? MiCA provides a whole like stablecoin kind of methodology, infrastructure, framework. Is this going to change the dynamic? Are we going to see regulated onshore USDC or US or Circle Euro or other regulated Euro stable coins really take off? And is this going to change the metrics? Something like 20% of global trade is settled in euros, but still 99% of all on-chain stable coins are US dollars. So tell me what you see coming for the stablecoin space and its impact on DeFi.
Yeah, I mean, in general, we see kind of course, that with MiCA, stable coins are being regulated as of June already, and that will impact also DeFi in my opinion, because if you once kind of because also centralized exchanges at some point will have to discuss whether they can still list unregulated stable coins or not. So for example, let's say if one of the larger or if the larger stable coins decide not to go for a MiCA license, then regulated European exchanges and brokers will have to have their decision made on whether they can still list those stable coins or not, or whether they have to offboard it. And this then, of course, indirectly also affects the DeFi market, because it will be, or it potentially, provided that centralized exchanges will offboard unregulated stable coins, it will be harder to get these stable coins and buy these stable coins in Europe, and therefore the volume could decrease. So I think it's going to be very interesting to see whether the larger stable coins will be licensed in Europe or not, and then also kind of how regulators will approach this and kind of whether they will force crypto exchanges to offboard non-regulated stable coins, or whether there might be a way to still keep them listed. So that is I think that will hugely impact the DeFi space, and of course also centralized exchanges.
Excellent. So thank you all very much. We are going to now shift into the last two parts of our presentation and discussion today. First of all, we've got some excellent audience questions I'm going to take and deliver to our panelists. And then lastly, we've got a bit of information and NFT and other stuff coming about our upcoming event. So let's start with some of the audience questions. I want to throw this out to everybody. We've been cheerleading MiCA. I'm actually very enthusiastic about MiCA. I think it sets a really great tone for the entire world and is very positive. And I hope we see regulators around the world follow more and more in this direction. There's got to be some negatives, right? And there's got to be some challenges or some significant sort of downsides to MiCA. And I want to hear what people think those are. Like, what are the things that do keep you up at night or make you worry?
I can start off.
You're smiling. You've got to have an answer.
I wrote my PhD thesis about what's wrong with MiCA, so I have a bunch of stuff to say about this. But one of the core things is MiCA has a structural core issue, which is it bases most of its definitions on already existing legal terms, which already cause issues across Europe because they're mostly in directives and not in regulations. So like while there should be a lot of harmonization coming in through MiCA, the actual scope of MiCA is a nightmare. When you look at the instruments scope, it's very hard for legal departments to deal with, and the regulators are also going to have a lot of fun with it. I also do think, and that's the second point I want to make, that some of the stablecoin regulation is not very well done. It really limits innovation when it comes to dealing with the reserve, when it comes to how stablecoins can be implemented, especially when you don't want to have a reserve, right? These kinds of things are sweeping changes to the market that will probably push players offshore, which makes it very hard for properly run and compliant exchanges to then deal with them and creates competitive disadvantages. And like, I'm really not happy as a crypto enthusiast to see stuff like this happen, right? To like actually directly go into how a product can be set up instead of creating guardrails around how you can deal with the risks that the products create. So those are my two biggest misgivings.
Very good. Other misgivings before I go on to the next question.
I think in general what MiCA does not very well is also in terms of the entire legacy setup. We are just talking about that we have thousands of tokens worldwide issued, probably also without white paper and all of that stuff. And the thing is, for sure, you have some leeway in the regulation, but still it's like very, very strict. And we are just talking about companies which are established worldwide and who also have, I would say a running business and also a value creation, what they are doing. And there, I think it's like really difficult when you just cut off those chains. And I think it's like when we talk also about, I think what Ralph mentioned on the EMT side, it's the applicability is as of July. And then basically it will limit a lot of projects, and I think will also push authorities to go a way stricter approach to interpret something as an asset reference or a token or an EMT. I think this is really, really difficult to handle at the moment. And I think also we do not want as a broker or as an exchange actually to kind of limit the product what we have on the platform and to limit the availability to the product of to the users, especially when you think about that. A lot of tokens are just used in the DeFi world, and as regulated player, you are providing them on the one hand with a very safe environment where they actually can store their assets, but also can go back into fiat if they want to. So I think for us, it's like really a balancing act to kind of still push the DeFi space, as it's kind of providing so many new business models, and there's so much innovation ongoing. But on the other hand, adhering to the regulation. I think this is something what MiCA does not very well, and where we will also need, I think, a lot more guidance going forward.
Very good, thank you. So another question that came in, and I'm going to direct this one to Martin, because I know you've been speaking to people all over the world. How does MiCA compare to, in particular, the post-Brexit UK crypto asset regulatory regime? Like, what are the implications for companies that are trying to do business in both the UK and continental Europe?
I think that's an interesting question. Kind of also what we see is that, I mean, again, what we see right now in practice quite difficult. That how brokers or exchanges, as Fabian already said, that are active worldwide, deal with the different regulatory frameworks right now. So what we see is kind of that MiCA has the framework that is probably the strictest right now. So a lot of companies are just trying to go for MiCA as their gold standard and implement MiCA regulations, and then try to roll that out also for other regulations that they want to adhere to. And what we see kind of with the UK, but Ralph, please feel free to add on here as well, because I know you also did some work on that, or in general kind of some legal literature on that. Is that UK at first was very vocal about being kind of supporting innovation and having a very innovation friendly regime for crypto assets. But what we see now is that in practice, especially also in terms of marketing regimes and everything, it has then be the reality was different. So that is kind of what I saw.
Yeah, the FinProm regime is quite restrictive in practice, and the problem is also in the UK, right? We still don't know what's coming. Like the MiCA Lite UK version, we simply don't know. And the thing that you also alluded to is like for a globally operating company, it's very hard because we have localization requirements in the EU, right? Your MiCA entity has to be in the EU. And then you probably get one in the US as well, right? And maybe one in the UK. And then you look at Canada, you have that too. And at some point, your global order book blows up, right? You have to split liquidity, which sucks for everybody in the market because everything gets more expensive, things get slower, client experience suffers. So I do hope that the global regulators knock their heads together to come to a situation where we don't have to split global liquidity, because we did manage to do that in MiFID, right? I do hope we can do it in MiCA, because why shouldn't we do it in an actually global technology while we can do it in TradFi? Kind of seems unfair and uncalled for.
Fantastic. These are great insights. We could. Oh, sorry. Go ahead, Fabian. We're getting close to the end of time, so keep it quick.
I just want to comment to this. I think especially with two broad marketing regulations, what we see with FinProm, you're basically just killing on the one hand UAX without, at many times, I would say, with an additional value for the customer, which is definitely a problem. And I think also we should not in Europe go into this direction that we are also adding those restrictions, because it will be just very, very hard to actually shift your platform to change the technicalities, and it makes just the entire user experience way worse. So I think education is important. Safe investing is super important. Having a very, very good and transparent set for the setup for the customers is important, but this should be definitely always in line with what is technical, feasible, and meaningful at this point.
Fantastic. All right, we have time for one more question. Speed round, just very quickly. Marie, you are talking to lots of EY clients. We talked about the difference between, say, MiCA and the post-Brexit UK environment. Tell me, within the EU, are there any particular jurisdictions that stand out for being especially helpful, friendly, exceptionally well organized?
Well, of course, we have to say it's Austria, because it's just the right place to be there, but also other jurisdictions that a lot of our clients are going to might be Malta, but this could also be the place. What we see in Germany is that it is in principle very well established, but the regulator is very strict there. So we see a lot of customers that go away from there. So yeah, there's a lot of places to go, but definitely the best feedback so far we got from Austria.
Fantastic. That's great. I appreciate it. So we are out of time for the questions to be answered live. We are going to download all the remaining questions, circulate them to our experts, and do our best to share the answers if we have good ones with everybody when we send out the slides. Let us go to the closing slides, because we got a couple of key messages towards the end. We've covered a Q&A, so we can go to the next slide. A book. Right? Do you want to really dive into sort of more of the basics of what are the use cases? How does this Ethereum ecosystem work? Please go and buy my book. It's called Ethereum for Business. It was called by Fortune magazine one of the best crypto books of 2023. I have been working in this space since I met Vitalik Buterin almost a decade ago. You can get it in multiple different jurisdictions, and all of the royalties go to fund blockchain public goods through Gitcoin. So that's the first key message. Second key message, if we go to the next slide. Would you like an NFT? So EY, we have an NFT platform, and when you're the global blockchain leader, you can make that NFT platform create a proof of Paul NFT. So if you scan that QR code, you can have the proof of Paul NFT. We make a new one every month. I have been told by legal, I'm absolutely not allowed to tell you that these will one day be worth millions of dollars, because they definitely won't, and you definitely don't want to get one of these NFTs. So take a picture of that now. 3, 2, 1. And we're going to move to our final slide in the interest of getting everybody out on time. EY has a blockchain summit. If you thought this sort of deep dive into regulation was good, we have a global blockchain summit. It's April 16th, 17th, and 18th. It's streamed entirely online. It's available for anybody free of charge. Day one is all about global regulation. We are seeing a global emergence of a regulated crypto and digital asset era. Day 2, we're diving into enterprise applications. And day 3, we're going to focus very much on scaling and privacy technology. So super excited to have all you join us there. You can scan the QR code and you can see the agenda. You can learn about the conference and you can register to participate. So, and as I said at the beginning, everybody will get a copy of the slides as well as these links if you register to watch this summit. With that, I want to close up just by thanking the incredible, excellent speakers that we have had today. Fabian, Ralph, Marie, and Martin, you are all true experts, and we are very fortunate to have you. And I have said this before, I'm going to say it again, summer is coming. This is going to be an incredible year, not just like geographic Northern Hemisphere summer is coming, but business summer for the crypto ecosystem is coming. And the incredible experience we've had in the market the last few months, that's just the early springtime. So with that, everybody have a terrific morning, noon, or evening, depending on where you are. Thank you for dialing in and joining us.